At this time, I would like to call to order the special meeting of the Johnston County Board of Elections for today, January 3rd, 2024. I'd like to begin by welcoming everyone here. We are also have the benefit of live streaming our hearing today for those who cannot be with us, but we appreciate those who are here with us today. And we always welcome people to come to our meetings, and we thank you for your interest. The first item on our agenda is the Pledge of Allegiance, and so I would ask that we stand and do that at this time. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next, we need to approve our agenda. To the members of the board, you've seen a proposed agenda. Is there a motion that it be approved?
Move for approval.
Is there a second?
Second.
Any discussion? If not, all in favor of the motion say aye.
Aye.
Any opposed? The motion carries. The next item on our agenda, which is the main point of today's meeting, of course, is the consideration of the candidate challenge procedural guidelines. With respect to that, I would like to call on the attorney to the board, Jennifer Slusser, also county attorney. Jennifer, please come forward at this time and give us your knowledge and expertise.
Yes, sir. Good morning, Mr. Chairman, members of the board. Happy New Year.
Thank you.
Before you have a proposed procedural guideline on how to handle candidate challenges. We have guidance from the state board. This is a little more specific with regards to the order of business, and certainly that is within your discretion. You may recognize this document because it looks very similar to a document that you have considered before with regards to protest petitions. So the process is essentially the same. What we are attempting to do, of course, is to provide due process to the parties that are involved in the challenge. And that due process means open, transparent business of the board, number one, and number two, the opportunity for folks to be heard. I provided a copy of this proposed guideline to each of you. I understand that Ms. Price also provided it to the parties and also to the chairs of each of the parties, and so I mean the parties to the challenge and then the actual parties. But that guide has been provided, and I would ask for your consideration in approval of this procedural guideline to help guide our business today.
Before we take any action, I open it up and ask if any of the board members have any questions of Jennifer about the procedure.
No.
Hearing none, is there a motion that we adopt this procedural guideline for today's hearing?
Move for adoption.
Second.
There's a motion and a second that we adopt this procedure. Is there any discussion? If not, we'll vote on the motion. All in favor say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Thank you, Jennifer. We appreciate your help as always. Next, we move to the main purpose of the meeting, which is the candidate challenge hearing in Ray candidate challenge of David Marshburn. Before we get into that, I need to make an announcement of sorts. I am, in my real life job as a lawyer, one of my clients is the Johnston County Board of Education, for whom I'm local counsel. This challenge, of course, involves the election of a member of the Johnston County Board of Education, for whom I serve. The purpose of the hearing is very important to lots of people, and a lot of people are going to be observing how the board proceeds, and everybody on this board wants to do the right thing, and one thing that I can certainly vouch for is that this board today and every day is going to do its best to be fair and impartial and to make decisions based on the facts and the law, and not based on any outside influences or biases or anything like that. But it's also important for this board to give the appearance not only of that it's doing the right thing, but it's not only important for the board to do the right thing, but it's important for the board to give the appearance to the public that it's doing the right thing and wants to do the right thing. And for that reason, because of my involvement with the Board of Education, I'm going to recuse myself from this hearing today. In so doing, I know that the board is going to do what the board would do whether I was here or not, and that is decide the case based on the facts and the law and do the right thing. But for purposes of appearance and to make sure that there's no question about any outside factors that may not otherwise be apparent, but that I know about because of my relationship with the Board of Education, I'm not going to take part in this hearing today. Therefore, before I formally exit, I would like the board will need to adopt or nominate and elect a chair for this meeting today in my absence. And so at this time, I would ask the board to, is there a nomination for someone among you to serve as chairman for this hearing today? And in the event that there are other hearings of this case, and I say that because I understand that there may be some interest of a party or parties that the matter be continued today, but whether it's continued today or not, for purpose of this case, is there a motion that or nomination for someone to serve as chair of this hearing?
I make a motion that John Shawcross be appointed.
I second the motion.
Okay, there's been a motion and a second. Is there any discussion? If not, all in favor of the motion say aye.
Aye.
Any opposed? John, you have the gavel.
And Mr. Shawcross, I would suggest, for purposes of clarity of the record, if the board is so inclined to make a motion to excuse Mr. Woodruff from this hearing because of the conflict of interest.
Right.
Chair would entertain a motion.
So moved. Second.
All those in favor say aye.
Aye.
All right. Thank you very much.
Temporary ex-chairman. I'll just try to slide up the issue. I don't want to be able to part from it. Are you? You never know what the day holds. All right. I'll continue on with the hearing, the special meeting of the Johnston County Board of Elections called to consider the consideration of a candidate challenge regarding David Marshburn, Board of Education, District 7, filed by Ronald Johnston. The procedures we're going to use today, I'd like to go over those before we go any further. All persons, including election staff, who intend to present evidence must be sworn in. The chairman, I'll call the case as advertised on the agenda, and the county elections director shall provide an overview of the matter. Evidence and the appropriate number of exhibits that were provided in advance of the hearing shall be given to the clerk, and any subsequent evidence will be numbered and entered into the record. If all the parties are represented by attorneys, the challenge candidate, followed by an opposing party, may present a brief opening statement. The challenge candidate shall present the argument and evidence in support of his qualifications, and we know whether it is or her, for the office, including residency. The county board can ask questions for clarification. Opposing parties may ask questions of the candidate and supporting witnesses at the time. And if parties are not represented, well, I understand both parties are represented by counsel. Is that correct? No, that's not correct. All right. If parties are not represented by attorneys, the chairman may prefer to delay cross-examination until all sides present their argument and evidence. The challenger or other candidates for the office may present arguments and evidence regarding the candidate challenge based on the applicable criteria. The challenger is not required to testify unless subpoenaed by a party. The challenge candidate may cross-examine the opposing witness at this time, and if the candidate is not represented by an attorney, the chairman may prefer to delay cross-examination until all sides present their arguments and evidence. Any other persons with relevant information concerning the subject matter of the challenge may present evidence regarding the candidate challenge based on the applicable criteria. Members of the county board may ask questions for clarifications. The parties may cross-examine the opposing witnesses at this time. Parties will be presented to present rebuttal to opposing testimony, and parties may, as necessary, object to incompetent evidence and testimony, such as improper lay opinion testimony or hearsay. After all evidence has been presented, the chairman may ask the parties if there is any additional relevant information that has not been presented. The chairman will entertain the objection and rule of admissibility of the evidence or exhibit. The chairman shall allow the parties to make brief closing statements, and unless the county board continues the hearing to a publicly stated date, time, and location, the chairman shall close the period for public discussion, and the county board will publicly discuss the case without further general input from the public. Members of the county board, however, may seek clarification or ask questions of persons previously sworn on any piece of evidence presented. Cross-examination and rebuttal may be made only on new evidence presented. And unless the hearing has been continued, the county board shall render decision on the matter, or if it is so chooses, recess the case to a publicly stated date, time, and location. County board must vote unless excused from voting due to impermissible conflicts of interest. The county board must sustain, deny, or dismiss the challenge in accordance with North Carolina General Statute 163-127.4D. The county board must find facts to support its decision. If the county board does not find a witness credible, it must say so and provide a basis in the record. A written decision is required. The written decision shall include findings of facts, conclusion of law as required by the same North Carolina General Statute 163-127.4D. And I believe that outlines our conduct of the hearing. So we will call the case of candidate challenge in David Marshburn, Board of Education, District 7, filed by Ronald Johnston. And at this time, we'll ask if there are any preliminary matters that need to be considered. And first, we'll call on staff for.
Thank you, Mr. Chairman. With regards to preliminary matters, I just wanted to make it clear for the record what documents were in the record at this time. And what we have is Exhibit 1 is the candidate challenge that was filed by Ronald Johnston dated 12/19/2023. Exhibit number 2 is the amended candidate challenge filed by Ronald Johnston dated 12/22/2023. And with that amended candidate challenge, there was a video submission. Exhibit number 3 is a subpoena to David Marshburn that was returned by the sheriff. Exhibit number 4 was a subpoena to Star Marshburn, which was returned by the sheriff. Exhibit number 5 was a subpoena to Johnston County Public Utilities that was returned by the sheriff. Exhibit number 6 is a subpoena to the town of Clayton that was returned by the sheriff. Exhibit number 7 is the affidavit of Chandra Farmer. And then I understand that the town of Clayton did deliver documents this morning, and the clerk has those documents for the board's consideration. You will note that there are some redactions on those documents, and the purpose of those redaction is to protect personally identifying information that is not public record according to the statute, and those are things like social security number, driver's license number, those sorts of things. So we're required to redact that information. But those documents were delivered by the town of Clayton today. So that is the information that we have in the record. I understand that this morning Mr. Johnston brought some additional items with him. Those copies have been made by the clerk, and I understand that once we get into the hearing that the intent is to present that evidence as he moves forward. And did I misspeak on that, Mr. Johnson?
No, ma'am, you are correct.
Okay, thank you. So that's the information that we have that is contained in the record at this time.
Thank you. Madam Director, do you have anything?
No, sir.
Okay. This is also the appropriate time and place to consider any motions.
May I approach Mr. Shawcross?
Please, sir.
Excuse me, sir. Good morning.
Order.
For the benefit of this record, my name is John P. Jacko Hale. I'm an attorney here in Smithfield. Was sworn in as oath of attorney in the old Superior Court room in September of 1975. I can tell you I have tried a lot of cases since that time, but I've never had a candidate challenge before. This is my first one, so please bear with me. I'm moving to continue this case today on behalf of my client, David Marshburn, and here are the reasons why. Last Friday afternoon, about 3 o'clock, I received a telephone call from an attorney who Mr. Marshburn approached to represent Mr. Marshburn concerning a subpoena. The only information I was given is that I needed some advice on a subpoena. And I told this attorney to have Mr. Marshburn call me on Saturday, which he did. I was out of town, and I told him I'd be back in my office on Tuesday after the New Year's holiday. I would be happy to meet with him then. I met with Mr. Marshburn shortly after 12:30 yesterday morning, and I reviewed the subpoena, and I went on in depth talking to Mr. Marshburn. And I came to the conclusion that this may be more than just reviewing a subpoena and delivering documents. This may be a hearing today. Now, I spent a lot of time yesterday afternoon and got up at 4 o'clock this morning to finish my research. I will tell you that yesterday afternoon, I think was somewhere about 1:45, I called Ms. Price because I didn't know who else to call. I didn't want to call the chairman because I didn't want to have any ex parte communications with him. And I advised Ms. Price that I had just been retained to represent Mr. Marshburn. And I would be asking that this case be continued. Now, I'm not continuing this for the purpose of hindrance or delay. As counsel for the board said, it's a due process question. The Supreme Court of the United States has defined due process as a meaningful opportunity to set a hearing date at a meaningful time and a meaningful opportunity to be heard for however long it takes for both sides to present their case. Frankly, I'm not ready to present this case today. I got on my computer last night and early this morning. I found a notice of hearing issued by Chairman Woodruff on, I think it was December I'm not sure what date it is, but I found it, set in this case for hearing is on December the 21st today. That was the first knowledge that I had, and I learned that about 4:30 this morning, that this was actually going to be a hearing today. I'm not prepared. I've heard about evidence and documents today that I did not know existed. I'm not asking for a long continuance in this case. I told Ms. Price yesterday if we could just continue it to Friday, I would be prepared to go forward on that date. I have trial scheduled today where the interpreters have been subpoenaed and witnesses are already subpoenaed to be there. I have a medical appointment tomorrow that's been long-standing, so that's why I suggested Friday. There's a lot to this case, and certainly Mr. Johnston's entitled to his day in court, so to speak. Mr. Marshburn has taken the time to consult me, and after I've really looked into it in depth, I realized that we're not prepared to go forward with a hearing today. For these reasons, I would ask that the case be continued. I mean, is Friday work for y'all, or whatever day would work for y'all, I'll make it work for me. Now, I know that everybody's been inconvenienced to be here today, and I recognize that. And had I known what this involved today, I would have gotten involved in the case a lot sooner. But I just yesterday got retained shortly after 12:30. So that's my motion, and I'll be happy to answer any questions that any of you have. And I appreciate the courtesies you've shown to me this morning.
Thank you, sir. Just a personal note, your pen is leaking.
No, it already leaked.
Oh. Your coat broke.
And you know David the cleaner out there,
Been happy to see you.
I tried to get it out, and my wife refuses to touch it, so, yeah.
Thank you, Mr. O'Hale.
I have several other shirts like that.
All right. Is there any discussion on?
If I may say
Mr.
one other thing,
Shallcross.
So you know I made a good faith effort. These are the documents I was able to download
Right.
between yesterday afternoon and early this morning. This was the only thing I started with yesterday. Thank you.
Thank you, sir.
Mr. Shallcross, it may be appropriate to allow Mr. Johnson to be heard.
Thank you. All right. Please.
Members of the Board of Directors, Acting Chairman Shallcross, thank you for hearing me today. I am just going to bring up General Statute 163, 127.4, as you've referenced many times, just to point out to the council and who he is representing that the Board of Elections is required by law. It says you shall render a written decision within 20 days. So that 20 days is from December 19th. Would not stipulate to a continuance. I am ready today. This is a simple matter of, does someone actually reside at a residence? It's not a felony trial. It's not something that would require discovery. This is not a court of law. He is not entitled to a continuance. This is a matter of, do you live where you say you live? And it's not something too complex to where it couldn't be heard in a matter of 20 minutes. But I do respect the board. I do respect their decisions. However, he is not entitled to a continuance. It is a very simple matter. Again, do you say where you say you live? And I'm concerned that this is a stall to take post-challenge actions to establish a residence where you do not reside. So I appreciate him being heard, and I would appreciate continuing forward in this process. Thank you so much.
Thank you.
And Mr. Shallcross, for clarification, the statute says that you should render a decision within 20 business days. And keep in mind, with the holidays and with the court closures for that period of time, we don't get to count weekends and those particular days. So there is some time to continue should the board so choose, but I would recommend that if the board is inclined to continue, that we do it post haste, because we do have that 20 business day deadline.
Thank you. Is there anybody else that'd like to be heard on this? Madam Director, can you tell us what the deadline would be to submit. I understand that due to recent election laws changing and moving the primary to a March date has complicated things with filing being before the holidays, and as our counsel pointed out, is included in that timeline, but we are up against printing the ballots and getting them out. So
Correct.
what would be our latest day to,
Well, I've contacted the State Board of Elections and talked. We are in the process of the ballot proofing process. The absentee ballots go out the 19th of January. That's the first day they can be mailed. The very last day that we can do any changes to the ballot is January the 12th, which is a Friday, next Friday.
okay,
Anything after the 12th, the names that are on there as of filing ended will be the names that will be printed on the ballot.
okay. How does the board feel about this motion to continue?
Does January 11th fall within the 20 business days since the challenge was issued?
Yes, ma'am. And I calculated just a minute ago, the 20 business days, because of those holidays and those sorts of things, actually the last day would be January the 23rd. But of course, that is not ideal with regards to the absentee ballots and those sorts of things. So the staff recommendation would be, if you're inclined to continue, that we get it done before that proofing deadline.
I have no problem with the continuance since it is a quasi-judicial hearing and candidates or those involved we are required to give them due process. So I would say whenever we can reconvene. I know there might be some staff. Are there any staff issues with when we could reconvene? No, ma'am.
What do your calendars look like?
I can't Wednesday of next week. Anything else is okay.
I'm available Friday of this week and Wednesday of next week. And then, no, this is this Friday.
Yeah.
And then Wednesday of next week. Monday and Wednesday of next week as well. Well, Monday, Tuesday, and Wednesday of next week.
I can do it anytime.
Okay.
Thursday would be a better day for me.
Okay.
Thursday.
Next Thursday.
11th.
It's Thursday.
No.
No, not day after tomorrow.
I have
That's
a
tomorrow.
medical appointment on that Thursday.
On the 11th?
Yeah,
She has an appointment.
What time?
10.
Okay. The 11th at 12 noon?
Will that give us enough time?
No. I won't be out of that appointment by 12 o'clock.
What about on Tuesday?
Tuesday,
Tuesday?
the 9th.
We don't have staff available on the 10th and the
The ninth?
9th. 9th and 10th.
Regrettably, I am not available on the 9th.
Okay. How about the 8th?
You can do it without me, but I don't,
No.
I don't know that.
I think we need you
the state
here.
board would-
Yeah, I think we need you here,
Considering
yeah.
in the book it says, make sure your county attorney's there.
What about the 8th?
I'm not available on the 8th. And the other thing was, if if we're going to give them an extension of time, I'd like to give them a time, yeah, rather than say, all right, you have another 24 hours.
Well, what about that Friday, the 12th?
We can do that, just,
All right,
you want to do the 12th?
we'll do it at 9 o'clock on the 12th.
9
12.
o'clock on the 12th.
If, I will entertain a motion to recess. Grant, the chair would entertain a motion. Twelfth doesn't work.
Sorry, my mic was not on. The concern with the 12th, from the staff perspective, is that you have to have a written decision adopted, which means that you would have to have the hearing, you would have to deliberate. I would assume that I would assist you in getting a written decision put together, and then you would need to approve it, and that would all have to happen that day. And I'm not saying that it can't happen, I just want you to realize that those are the things that would have to occur on that day if you did the 12th.
I think we can do it, oh, really? I was gonna say we could do it here, even if we had to work overnight here. Or we can do it on the 10th. The 10th?
Will the 10th work?
The 10th.
I should not press these buttons. The 10th works for me. From staff says, technical staff says the 10th works for them. Election staff says the 10th works for them. Are the parties available on the 10th?
I'll be there. Yes, absolutely.
I make a motion that we adjourn and reconvene on the 10th
Can we,
at 9 o'clock.
John has
would you recess until?
Well, recess? Okay. We recess until then, okay.
Second.
All right, there's a motion and a second that we recess today and reconvene on January the 10th at 9 a.m. All those in favor say aye.
Aye.
All those opposed? Thank you very much. We will see you on January the 10th.